Law Group, which is a law firm concentrated in men's and fathers' rights in divorce, custody, and family law issues, with offices in Nutley and Montclair, New Jersey. Today is July 31st, 2019. As I said, I am in New Jersey, so the information that I'm about to give you, you always have to make sure it applies in your jurisdiction if you're not in New Jersey, and if it hasn't changed if you're watching this at any later date. Today is my weekly how-to series where I try to give you a little bit more information than I do with my daily tips about a certain topic that I find often confronts clients or potential clients in cases. So today I'm going to talk about how to take a deposition, because depositions can be very nerve-wracking and difficult and challenging for clients, because it's the first time probably that you're going to be giving testimony, and being uncertain about what to do and how it gets used could really cause a great level of anxiety that's really not necessary. So my opinion is to prepare for a deposition is to understand what a deposition is, how it's used, and what you can expect. So that's what I'm going to cover for you today. So first, let's talk about the purpose of a deposition. A deposition is where you're going to sit in a room and you're going to answer questions under oath with a stenographer that's going to usually be typing up what you're saying verbatim to be transcribed later and possibly used in court. The main purpose of a deposition is supposed to be to gain information, which is generally what you're going to be doing long before you go to a trial. Secondarily, though, you can use a deposition for other purposes, and you need to be aware of that. Sometimes you're using it to let the deponent, which is the person who's answering the questions, get a feeling of what it's going to be like when they go to court. So if you're an aggressive trial attorney, you may take an aggressive deposition so that the person that's answering the questions, which would be you if you're watching this video, gets uncomfortable and concerned about going to trial and thinking that it's going to be just as bad, so they get less inclined to want to go forward. It also can be used to sort of unnerve the deponent or the person giving the answers. Again, similar for the same reason as to discourage future litigation. But ultimately, it should be used to gain information. And that's really what you want to try to keep your mind focused on, even if there's do appear to be using it to unsettle you or for any other purpose. Second thing to realize is the type of questions that you're going to be asked. Now, the rules of court in New Jersey allow you to ask any form of question that you would be able to ask in a trial. Now, normally that's going to be leading questions, but in a deposition, you're still more likely to get what's called open-ended questions: who, what, why, when, and how. These are going to be intended for you to give as much information as possible. The person taking your deposition would like you to ramble as much as possible. If you were my client, I would want you to do just the opposite. I tell my clients as a guide that your answer should be less than 5 words. If it's more than 5 words, you're starting to ramble. Now, it's obviously not a bright line rule, but it's something you just want to keep an eye on. If you find yourself going on, you don't want to do that. It's the person who's taking your deposition, it's their job to get the information from you. Let them elicit it. Let them think of the question that's necessary to get the information. If they ask you a very simple yes or no question, just say yes or no. And this is very important. I've been giving this advice for decades, and nobody follows it because it's very challenging. When you're asked a yes or no question, just say yes or no. The reason why people don't do that is they get in their head and they start thinking what the answer suggests or how they're going to look or how the judge may think about them later. So they want to say yes, but, or no, because. And the yes or no is never what hurts you. It's always what you follow it with that can hurt you. So you never ever want to offer anything more than was demanded by the question. So when it's a yes or no question, only keep the yes or no. I can't tell you that hard enough, both in a deposition and in a trial, even though this is not really about trials. Third is to understand what is relevant in a deposition. Now, in New Jersey, unfortunately, to some extent, anything is relevant in a deposition, which means technically they can ask you things that have nothing to do with your case. So if you're in a divorce case, they could ask you about medication that you take as a child. They could ask you about your family's mental history. They can ask you about your current sexual habits and tendencies. Now, technically, you're not able to refuse to answer that type of a question because it's supposed to be considered relevant. But there is a sense of decency that cannot be crossed. So hopefully you're going to have an attorney in a deposition. He or she will know when that line is crossed and when it is not. So even though there's a broad scope of what is considered relevant or important, it doesn't mean they can really ask you anything that they want. If they do, one of the weapons that your attorney will have is to insert an objection. Now, an objection is going to normally be something about the type of question that you received. Your attorney may object because the form of the question isn't proper, or that it's asking for certain information that's not proper. So before you answer the question, always take a second, first to make sure you understand the question. So let it process before you jump into an answer. Second, you want to pause because your attorney may want to insert an objection because there might be something wrong with the form of the question. It might be ambiguous. It might be suggesting something that's not true. It might be leading you in a direction that it's not supposed to. You want to give a second for your attorney to put that out there. And also, when your attorney objects, it's not likely to mean you don't answer the question. You still will have to answer the question, but the objection is there to allow the person who asked the question to cure whatever the defect is. So for instance, if your attorney objects because the question is vague or ambiguous, the person who's taking the deposition should rephrase the question or question you in such a way to eliminate the ambiguity or the vagueness. If they don't, so be it. But that's what it's intended for. But what you also want to do is pay attention to the objection, because in a lot of cases, the attorney's objection not because he or she needs the record to be clear about the objection, but they may be trying to indicate to you that there's something in the question that you want to pay attention to. So if they say, I object, the question's ambiguous, think about that for a second. Think about what could be ambiguous, what could be misleading in the question. If it's vague, think about what you might not understand, because you are able to ask questions. You are able to say, I don't understand that. You are able to say, can you repeat that? Can you read it back to me? Take your time and always make sure you understand both what the question is and what your attorney might be suggesting through any objection. Now remember, as I said, if the attorney objects, it doesn't mean you don't have to answer. You do have to answer unless your attorney says, do not answer. There are limited reasons to refuse to answer a question. Normally there's going to be privileged information like medical information, unless of course the medical information is relevant to your case, and attorney-client privilege information and things of that nature. Excuse me one second. Normally your attorney is going to object and tell you to answer the question or not to answer the question. Now, in some limited circumstances, you may be refusing to answer a question with the advice of an attorney, and the person taking the deposition may think that's inappropriate. What you should be doing at that moment is contacting the judge that's assigned to your case and putting forward what the question is, what the objection is, and asking the judge to make a decision as to whether or not the answer should be given. I always call the chambers of the judge assigned to my case before I take a deposition to make sure that the judge and or a law clerk is available to take that call in case this issue comes up, because it does come up quite often. If you find that it comes up and you're unable to get a judge on the phone, even if you talk to the judge's chambers and they were supposed to be available, they may not be when you call. You may then just need to continue the deposition and get back to the question on another day, even if you have to reconvene the deposition to do so. Next is to understand how deposition transcripts are used. As I said, when you testify, you're going to have it transcribed. Usually it's going to be a person physically sitting there typing it up, but sometimes it's done electronically now. That transcript can be used in court against you. Now, it's normally only going to be used for two reasons. One is if you lie or change your answers under oath, and it'll be used to show that you gave a different answer before, which is impeaching your credibility, or if you become unable to testify or unavailable for some reason. You may not be a party, you may be a witness, or for some other reason not able to testify. So that's important to realize even going in, because you don't need to be so concerned about your answers if you stick to the truth and you keep them brief, because the deposition answers will only be used against you if you say something different when you get to trial. So if you stay consistent and simple, that's unlikely to happen. Lastly, just some basic information about deposition to understand in New Jersey. First, they're considered continual in nature, which means when you start on one day, if you do not complete it that day, you should be scheduling it and be prepared to continue it the very next day. Now, that doesn't always happen that way because there's a lot of people involved in the deposition and it may not be available, everybody may not be available the next day. So it can be scheduled at some other time, but you should be prepared for the fact that it could go into a second day. Second is you're going to be under oath, so it's testifying just like you were in court. If you do lie and it is discovered, you can be charged with perjury, very significant, and will also undermine your case significantly. The role of the person of your attorney defending you is very limited. As I mentioned, it's only to object. In some cases, the attorney taking the deposition will say something like, all standard objections are preserved on the record. What that means, if it's said in the beginning, is that your attorney doesn't have to object for certain things like vagueness, ambiguity, assuming facts not in evidence. They will be assumed even if they're not stated. So your attorney may actually even be doing less than what I said, and he or she may be quiet throughout the whole deposition. It doesn't mean he or she doesn't know what he or she's doing. It means that a role of what's considered the defending attorney is very limited in the deposition, so you need to understand that. And the last thing is there's a little bit of an ambiguity about whether or not you're allowed to talk to your attorney in between breaks. Now, when you're on the record being deposed, you cannot ask your attorney questions unless you ask the deponent and you get permission and it's put on the record. But generally, you're not going to be communicating with your attorney. You do have the ability to ask the person taking the deposition questions if you don't understand something or if you want something clarified, but you will not likely be able to communicate with your lawyer. Now, in New Jersey, in state court, when you take a break during the deposition, there's no prohibition against talking to your attorney about the nature of the deposition, the questions, or your answers. But in the federal court, which has a separate set of rules in New Jersey, there is a prohibition that says you are not supposed to be speaking to your attorney during the deposition. My practice is to adopt the federal rule and not speak to my client in the middle of the deposition, not because it's prohibited, but because I think it's safer, because it avoids any question of taint or coaching that could arise. It keeps any kind of privileged information from being exposed because there might be people listening or it might later become discoverable. So that's my approach. It's not necessarily what you need to do, but it's something that I would recommend you consider. So that's about all I have for depositions. They are not as challenging as they seem. They're not as significant as you may consider, depending on the nature of your case, obviously, and the consistency of your testimony, but it's good to be prepared. You certainly want to meet with your attorney beforehand, get a sense of what more to expect. This is just a soundbite as to what an average deposition is like, but yours will be very different, and everyone will be different depending on the nature of the case and the issues of your case, and also the parties involved. So it's always good to have some preparation, maybe even go through a question, trial, and answer. I usually do with my clients the day before, run them through what it's going to feel like so you get a sense of answering the questions before you go in. If this information was helpful, I'd appreciate it if you would give a like and share this video so others get to see it. Feel free to leave me any comments. I always address any comments I receive. It also helps me improve my videos in the future and provide more information that you may look for. And with that, I'm going to sign off. I will be on tomorrow, hopefully, although ironically I'm in a deposition tomorrow, so I'm not sure if I'm going to make it and what time, but I'll do my best. If there's something you want me to cover in the next day or so or whatever it may be, just send me a message. I'll do my best to cover it.